We also, just so you're aware, haven't tried to deal with hot tubbing, which is obviously a form of experts meeting, but then with the judge present as well. So we've excluded those from our discussion this evening. But obviously if people want to ask questions about it, we'll be happy to try and entertain those at the end.
Meeting or discussion. We've entitled the talk, The Experts Meeting, but those of you who were observant will have noticed that in the rules the word meeting is not mentioned at all. The word that is used is discussion. And you do not need to meet in order to discuss, and in many fields of work, in particular the medical field, very often it is simply impractical for the experts to meet. They're in different parts of the country, and they've got far too many other things to do, and so they hold a discussion on the telephone. And that will comprise the experts meeting, and following that, then a statement will be prepared. In other fields, particularly for instance in the construction field, where you're dealing with plans and possibly even models, or you might require a site visit, then it will almost certainly be essential for there to be a meeting. And so whether it's a meeting or a discussion will again be something that you can discuss with your opposite number as to what you feel is necessary in the context, and obviously you have to bear in mind practicality and expense as to which is the most appropriate way to deal with the discussion.
I always actually prefer to call it a meeting because I think it makes it sound more formal, and since it's ordered by the court, it is really, it sets it out with a more professional air to it than something that perhaps you're just going to wander through a whole lot of subjects and topics. But it's both, because it doesn't mention meeting in the rules specifically. Now the first part really, whenever you get on to doing a meeting, obviously, is setting the agenda. What are you actually going to discuss? What is the subjects that you're going to deal with? And the rules are really quite interesting here, because the agenda can be set by either the solicitors or the experts. And in fact, when you actually go back to the rules, you can also have questions specifically identified by the court. I've never actually had that happen, that the court has directed that the experts talk about something, perhaps because I've always managed to cover the aspects that the court wanted to. But it is perfectly possible for the court to insist that actually certain things are discussed specifically. The process of actually doing it, I would suggest to all of you who work as experts, you do it with your instructing solicitors, and at every stage consult with them about how the questions are going to be phrased, how they're going to be set, and how they should be presented to the other side. And it is required that the questions that the experts consider are not leading questions. In other words, they're not intended to frame the whole discussion from one side or the other. Sorry, please make yourself at home. Where the solicitors do it, they should do it in consultation with the experts, so you have an input into it, and they may have specific things that they would like you to discuss as well. And therefore it becomes a joint setting of an agenda between you and the solicitor who've instructed you, and the other expert and their instructing solicitor on the other side. Occasionally, I've been in a situation where it wasn't possible to agree, and the other expert eventually said, "Oh, stuff it, let's just go ahead and talk about what we've put in our individual reports." It wasn't such a successful meeting, I don't think, and it was much harder to write up afterwards. So I would counsel you all to actually make sure that you have some specific defined points that you have had to write up and form a view on in your report in order to actually focus on those individually as you go through the meeting. So, working with your solicitors. This is very much how you actually run the meeting. But working with the solicitors at the first point hopefully has been helpful. and then subsequently you can actually decide with them actually what the points are that you are wishing to make, and they may well have input as to what they think actually are some of the relevant issues as well from their side. You are not bound to follow what they say. You are the expert, you're the one who's running the meeting, and it is very much an experts meeting. So although you're working with them, and probably up to this point it's been the solicitor who's been driving the work as far as deadlines and essentially the reports and how they're put in, at this point you are very much the ones who are in control. And it's very important that you have read your report before you go into the meeting again. I suggest literally the night before or the morning if it's an afternoon meeting, and make sure you are absolutely on top of what your arguments are and the basis on which you made those decisions. Attendees.
Yeah, just before we move on to attendees, on working with your solicitors on the agenda, it's very important when drafting the agenda to ensure that the issues encompass not only what you as experts consider to be important issues, but also what your instructing solicitors advise are the important issues that the court is going to have to determine. And there may be issues which, or ways of looking at expert issues, which won't be immediately apparent to you, but are relevant to the way the court is going to decide, for instance, an issue of causation or the like. And it's important that whilst drafting the agenda, whether it's drafted by the solicitors or it's drafted by you in conjunction with the solicitors, that you fully understand the importance of items on the agenda to the case that your instructing solicitors are intending to address at court. Now, the next slide, attendees, I think we've really covered this already whilst dealing with the rules as to who attends and who doesn't attend, and I don't think I've really got anything more to say than we've already said.
Without prejudice. Now this is probably the most important guideline behind all the discussions that go on at the experts meeting. What you say at the expert meeting is always done on a without prejudice basis. And when you start to draft the memorandum after it, it is again without prejudice until you have both agreed what the content is. Okay? So when you send it to your other expert, make sure that it's got without prejudice on it, and make sure that as it goes backwards and forwards it retains without prejudice until you get to the point of signature at the end of the day. Okay? Now, in order to try and help you with that, we've included in your packs, which you'll find on your chair, a sheet which actually is in landscape mode. Now, there's nothing really here other than being what I take to my experts meeting. It gives you an opportunity to put the agenda items when you get to page 2 down the left hand side, and then I normally actually make the boxes bigger. This is just the template that I use, and then you can put down your points of agreement and your points of disagreement on the far right hand column. And therefore it gives you quite a good structure to make sure that you explore the individual points fully and you record accurately that you've actually discussed the relevant points that you want to pick up. It's also quite good as an aide memoire because you can change the names at the top from claimant and defendant to your individual, who's meeting, who the experts are, and where you're meeting. And you can see up in the top left-hand corner, without prejudice, which of course you take off if you were to use this format, although it usually then changes into a memorandum form. when you actually come to the end of the day. But the most important real part of this is that it actually means that you can start off and actually say to the other expert that these discussions are on a without prejudice basis, so it sets the framework. And you can see that's the top point in the points of agreement. Subsequently, you can actually agree on that the fact that you are meeting under the CPR 35 rules gives you 2 points that you agree on before you even start, which is always nice because it's always good to find at least some points that you can agree on. Then you can agree on who the claimant and the defendants are. That should be relatively obvious. But sometimes, obviously, in more complicated cases, particularly where you've got Part 18 litigants involved, then it may be other people that are involved in the action as well. And then finally, you come to the chronology. Do you actually agree that the road accident happened on a specific date? Do you actually agree that it's a concerning, money that actually was apparently missed from an account on a specific date? Well, are you both looking at the same statements? And it's really useful from going through your expert reports, both yours and the one from the other side, to ensure that both of you agree the basis of what you're talking about. It's never happened to me that you actually have ended up disagreeing about the individual dates, but sometimes people have different views on it, and you probably will have already picked that up from the other expert's report because it doesn't agree with your own chronology. And then you can get on to the detail actually in going through what your agreed agenda is, which is page 2. And then if you write it up nicely and you've given yourself sufficient room, which frequently I haven't in the individual boxes, then you can both sign it off at the bottom to say that you've had the meeting. These were the minutes of the meeting, and which are without prejudice, but you can then draw up the memorandum from that. And it gives the other expert a chance to actually think about what they've said, but it also gives you a chance to think about what you've said and actually how you want to express it in the final memorandum, which then is the without prejudice document and goes to the court. Yeah, of course.
One of the things that Thomas just said reminded me of something which it's important to bear in mind, which is when he was talking about agreeing on the date of an accident, for instance. It is unlikely that what date the accident was on is a matter of expert evidence. That is likely, it seems to me, to be a matter of fact. Now, matters of fact are ultimately for the judge to decide. And you may find during the course of your discussions that you and your opposite number have essentially been working on different facts as presented to you by your respective instructing solicitors. And if this has not been teased out already in the agenda, as it should have been, it is as well to remember that where there is a dispute of facts, a judge may decide either that one occurred or that the other occurred, and different expert results may depend upon which of those facts is found. And so what you may need to do in the course of your discussion is to discuss, well, if the judge were to find this, what is our opinion? And do we agree? If the facts are found in a particular way, do we agree on the expert result? And you may need to, as it were, have a, if this has occurred, this is our view, and we agree for these reasons or disagree for these reasons, or if this is found as a fact, then we agree for these reasons or disagree for these reasons.
The date of a motor car accident obviously is normally relatively well sorted out early stage, but certainly I'm looking at